If you would like either of these UCC filings done correctly on your behalf, don't hesitate to contact legalregistration.com or call 877-955-7111. Today, we're diving into the fascinating world of UCC forms. I am your speaker, here to guide us through the intricacies of these forms and their importance in business transactions. Thank you all for joining this presentation, sponsored by legalregistration.com, your go-to online incorporation service provider. Today, we'll be exploring the essentials of UCC1 and UCC3 forms, the core documents used for filings under the Uniform Commercial Code. First, let's delve into UCC1 forms. These documents are essential for putting creditors on notice about a claim on a debtor's assets. Since 2013, we've been following the organic public record rule, which sometimes still causes confusion. We'll clarify how to handle due diligence and avoid common mistakes when dealing with UCC1 forms. Next, we'll discuss UCC3 forms, which involve multiple parties and the jurisdictional 120-day rule. If time permits, we'll also cover some recent developments that impact how law firms conduct due diligence. Let's begin with UCC1 forms. Why do we file a UCC1 financing statement? Primarily, it's to notify the world of a security interest in a specific asset. It's also about perfecting your security interest, as required by Article 9, and ensuring priority in case the debtor cannot meet their obligations. A UCC-1 form is used nationwide, but be aware that there might be some variations by state. For example, Florida and Tennessee have stamp taxes, and Illinois has specific font requirements. Despite a model form being accepted in most states, always ensure you're using the correct form for the state you're filing in. Remember, a UCC1 form is a legal document and part of the public record. Think of it like evidence in a court case. It should be treated with care, as it holds significant weight in legal agreements. To be legally sufficient, a UCC1 form requires three things: the exact name of the debtor, the name of the secured party, and an indication of the collateral covered by the financing statement. The description of the collateral doesn't have to be overly detailed. It can be broad, like all assets, or more specific, depending on the parties involved. It's essential to use the exact legal name of the debtor, as per the most recent charter document. This means you can't rely on documents like certificates of good standing. Always use the most recent charter document to avoid any issues with your filing. Moving on to UCC3 forms, these are used for amendments, continuations, and terminations of UCC1 filings. It's crucial to handle these correctly to maintain the priority and security of your interests. Before we wrap up, let's address some common pitfalls. Punctuation, spaces, and exact names matter. For instance, using "and" instead of ampersand or changing the format of numbers can lead to rejected filings. Always ensure that the name on your filing matches the name on the charter document exactly.